Computer tells me that it is 1 o'clock, and that's the time that was noticed and posted for the agenda for an emergency Board of Supervisors meeting pursuant to ARS 38-431.02D. Notice is hereby given that the emergency session of the Cochise County Board of Supervisors will be held on Wednesday, October the 26th, 2022 at 1 p.m. Board of Supervisors Executive Conference Room, 1415 Melody Lane, Building G, Bisbee. Any item on this agenda is open for discussion and possible action, and we'll begin with the roll call. District 1.
Good morning or afternoon, Madam Chair. Crosby is here.
District 2, Supervisor English is present. District 3.
Supervisor Judd is here.
We have a complete board. Members of the public may also attend this meeting by Microsoft Teams computer or mobile app, or by phone by calling 602-609-7513 or 888-680-6714. Conference ID 407-970-40#. If you have trouble accessing this meeting remotely, call 520-432-9200 for direction. We do have 2 listed action items from the Board of Supervisors. The first one is direction and action regarding a response to the Secretary of State. And I'm not sure how to put a motion. Should we have a motion on the floor before we discuss this? I'll ask for legal advice. That's the normal procedure.
I think we need to proceed with a motion in a second, and then after that, I can explain the basis of the emergency meeting.
Okay, so I need a motion on the floor so that we can have discussion.
Madam Chairman, I move that we seek at this moment direction and action regarding a response to the Secretary of State letter dated October 25th, 2022.
Second.
Okay, I have a motion and a second. So now we can have discussion. Mr. Kowalczyk?
Yeah, the basis of this emergency board meeting is that yesterday the board received a letter from the Secretary of State, Katie Hobbs, indicating a response, and that they needed a response to this letter by 5 p.m. today. There are 2 requests or clarifications that the board will not attempt to conduct a full hand count of all ballots cast in Cochise County under the false premise that it is proceeding pursuant to ARS 16-602B, and the board will follow all applicable requirements and statute and in the EPM when conducting its expanded precinct hand count audit under ARS 16-602B. It later states that they need these assurances from the county, and that it needs to be responded to by 5 p.m. today, otherwise that they'll seek legal action. So that's the basis of why we have the emergency board meeting. In addition, the board can respond or not respond to the letter. And I think they're looking for clarification of what transpired based on the vote that happened on Monday. So, and it is from the agenda item and the discussions and the work sessions and the clarification of what was voted upon, what was stated at those meetings, and I need clarification from the supervisors in this manner. It seems that the board, based on that vote, will proceed with 100% hand count audit of all races and all ballots cast on election day, including 100% hand count audit of all races and all early ballots, which will be conducted by the Cochise County Recorder, David Stevens. That this hand count audit will be in addition to and not replace the normal election tabulation process to assure agreement with the voting machine count, and that this process shall be completed prior to the canvass of the general election results. So those are together what the supervisors have stated before. Is that accurate?
I prepared a response, and I'm sorry that my voice is still hoarse. That's very unfortunate. The response goes like this. Dear Secretary Hobbs and Ms. Corrick, we know we have lots of work to do. If you care to assist, please contact County Recorder Stevens or Elections Director Mara. Best wishes in your future endeavors. Signed, Board of Supervisors.
And if
Jen?
Madam Chair, yes, looks like Supervisor Crosby's finished. So I did not prepare a statement that I'm going to read. Yes, many of those things that you just read may have actually been from Tom's kind of directives as well, not mine. The one that passed, I didn't ever really see what the next steps were on Tom's proposal. I have no idea what that was. But all along, I intended to follow every law that was applicable to hand counting, which is basically what Katie says. The board will follow all applicable requirements in statute and the EPM when conducting its expanded precinct hand count audit. She did give instruction how we would use the voting centers as a precinct, or instead of a precinct, which made perfect sense. She did, there are requirements to follow, and I anticipated that we would, as I was kind of having trouble with believing that we were doing something illegal. I mean, while it may be hard to do, hard to accomplish, it might take a little extra time and even a little extra money, which the Senate does have that available for us. I've assured that in 100 different ways. Well, not 100, but a few different ways. Flipped it upside down. I got that. I got that. If we have to have expenses involved, the Senate has money for that. They will grant us that money. I just need to say, I want to do it. She says, we cannot conduct a full 100% hand count. We can only do 4 ballot items. Just that's in her rules here, and I'd seen that before. And someone else from Phoenix pointed that out to me. According to statute, we'll be able to do 4 contested candidates. And I'm sorry you can't see me. My camera's broken on my computer. I discovered that this morning. So anyway, 4 contested races plus 1 ballot measure. I can't remember how that was decided. There is something here about how we can't hand count the early ballots, and I haven't looked into that very much. I haven't even talked to Mr. Stevens about it, but c'est la vie, we'll do what we can. I think we're at a place where if we back out, any of us, any individual backs out, then people are just going to have more mistrust. And I'm not about creating trust in one population and creating mistrust in another. I'm talking about doing an excellent job of hand counting, what we can make comparable measures to. Secretary Hobbs basically sent us a letter that said, okay, you can do it if you do it on my terms. And quite frankly, I'm willing to do it according to the law. And I'm willing to make that statement to her. We will do it, as you said, according to the law. We recognize that we cannot do, according to the law, a full 100% hand count. We recognize that. It was one reason why when I looked back on the agenda item that I let mine go, because mine said 100% and his didn't. And that was one of the reasons when I looked back, I thought, wow, it's a good thing we passed number 2, because his just said a hand count of every precinct. It doesn't say, it says full weight. I don't remember what it said, but we can't do everything according to the law. But I want to do what we can according to the law. So I'm encouraged that we have a meeting set tomorrow to try to see what's happening. And if for some reason at some point we have to scrap the whole idea, at least we tried. I don't know, that's been my experience working for or being elected in this county for a long time, is I've tried a few things that have had to be scrapped, or tried to get help for someone that just couldn't be helped. And even when in all senses of the word and legality, it looked like it could, but it couldn't, or it should, but it couldn't. I'm just kind of used to that. And at least if you, in my experience, if I do my best, then it's okay. So I'm trying to win a few followers to the, hey, Cochise County really is the best county to live in and the hand count's going to work. And I can tell you, since the vote, I've gotten way more thank yous. I mean, I realize that there's an opposition to this, and the newspaper didn't do us any credit today. But since the vote, I've gotten way more thank yous than people saying, whoa, I think you made a bad decision. And Katie Hobbs basically says here, it's not illegal as long as you follow the law. So I'm interested in finding out how closely we can follow the law and make some meaningful comparables and kind of check our machines out as far as we can. And every day I pray now. I was praying I would just get through the last 2 weeks, but every day I pray now that our machines and our hand count are perfectly matched. And I'm a pretty faithful person, so I'm hoping that this does what we want it to do and doesn't backfire, but I don't see it backfiring because our county's amazing. I talked too long. Sorry. Everybody's doesn't know what to say. I'm gonna mute though, because I have a 2-year-old in the background, and without hollering for his dad, I'm gonna have to mute. Sorry.
Let me interject and say I heard both of you, but I didn't hear you saying the same thing. And I didn't hear any details. Either one of you want to clarify what you see as, I mean, you use the word, I want to do what's legal, but yet
I want to do what Katie says.
Okay.
We need to confirm in writing that we will not attempt 100% full hand count. We need to write that in writing. And I don't want to talk about the false premise. That's ridiculous. but we won't, but we will put that aside, the false premise part. We'll abide by all the statutes, not just 16602B, and the board will follow all applicable requirements in statute and the EPM when conducting its expanded precinct hand count. And she's calling it an expanded precinct hand count. I'm okay. And she did clarify that the precinct was, in this case, going to be voting centers in her text in the letter. So that's my comfort level, saying we will abide by all the laws, and we will, because fortunately, unfortunately, or fortunately, we are at a place where we will be following the laws. We're being watched. We're being carefully controlled for good reason. I'm willing to take that and still conduct an expanded precinct hand count, which in our case would be vote centers. So.
And how do you surmise that being accomplished, Peggy?
I guess we're going to decide that tomorrow at our meeting when we actually have staff there to discuss it with. It is very possible. One of the things that has been said a lot is that how are we going to even count all the ballots? There's 80,000.
We need to be
our
careful
county
straying away from your agenda item here.
Oh, okay, sorry. Okay, I won't talk about anything else said. I don't, it's not my job to accomplish this. We will do that together. There is a meeting tomorrow.
Yeah, my apologies, Supervisor Judd, for interrupting you, but I think the item on the agenda is
to respond.
The response, which then I don't think includes, understand the meaning behind your question, Chairwoman English, of, well, but how? So I think the main issue for you today as a board is whether a response is sent, and if there is a response, what direction to give regarding the language used in that response and who actually signs it. Is it going to come from the chair? Is it going to come from Supervisor Crosby? Is it going to come from the county administrator? And so that I think is all that's on the agenda rather than the specifics, which are the subject of a work session tomorrow.
Right.
I would like to reiterate what I said.
The response was to, are we going to drop the hand count, or are we going to do a hand count of what?
Madam Chair,
Yes,
if I may.
certainly.
The direction has already been passed to the county recorder or elections director. That's what I said in my letter. That's who she should contact. And I hope that her office would care to assist.
If I may,
Yes, go ahead.
I think it's confusing of what was voted on and now what has been discussed right now, because what's being discussed and Supervisor Judge stated that, yes, we need to respond in the affirmative to both of these propositions, that we will not attempt a full hand count, and that we will follow all applicable statutes and election procedure manuals. So if that's the response, Supervisor Crosby is stating a different response.
I guess that's what I was saying. I'm not hearing the same thing from both of you.
I'm willing to have no response.
But I think there needs to be consensus of what the response is so that.
I was muted. My gut feeling is to wait till after our work session, ask for an extra day till we've had a chance to talk about if we can even do it. So, and I'm thinking we can. I'm of the understanding that we can. I believe we can do it. I've had a chance to discuss with a lot of angry people this morning about the editorial. And so some of them even have decided, yes, you can do it if you can. But, you know, when we follow all the laws, they're not as nervous about it. I would suggest if we can't wait till after we've had a chance to decide how far we can go, so we can tell her exactly what we decide we're going to do with our recorder and our elections director, who aren't in the room, I'm guessing. If we can't wait till after we decide how far we can go with the people who have been given the task of doing the job, I would suggest we say we're going to conduct the expanded precinct hand count under statute 16602B, as she suggested, and kind of leave the false premise part out, but actually say, you know, we understand with the statute that we will not be conducting a full 100% hand count. She mentioned 100% earlier in her letter, so I'm sometimes the 100% keeps coming out, but what I actually voted for the other night was not actually 100%. It was of all the precincts. It didn't actually say 100%. So in my opinion, a full hand count doesn't necessarily have to be 100%. But if they can't wait till we've had a chance to discuss this with those two people and work out some of the details to where we know what's even possible, I think we just pretty much have to say thank you for the olive branch and move on. You know, go on to our meeting tomorrow.
I'm still confused.
So say the board will not attempt to conduct a full hand count, but will proceed with an expanded precinct hand count as the secretary has allowed, following all applicable requirements in statute and the EPM. That's what I would say. And actually maybe say thank you for weighing in, and we'll take, for what Crosby said, Supervisor Crosby said, we will take any help you can give us.
As long as it's help.
I'm going to assume that it will be. This letter was amazing. What they sent to us today, giving us a chance, was amazing. They aren't happy about it, and they still did. They still gave us a chance. I wrote a thank you letter to them.
Comments, Tom?
I'll just go back to my original letter, and if that isn't enough, then they can go back to the voting results from our meeting on the 24th. That's plenty of clarification. However, I will offer this further bit from page 2 of her letter. It says, The secretary, like the Cochise County attorney, continues to have serious concerns about the legality of the agenda item, particularly yada, 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 yada. Okay, that's fine. She has serious concerns. She can have those serious concerns. She's not saying it's illegal, and so I don't think it's illegal. And so I like my letter. Or no letter. We don't need it. I mean, everything's on record already. The meeting results, the voting results are on record. They have that.
But
And-
if I may,
Yes,
Chair.
Mr. Kowalczyk, go ahead.
So I still think it's confusing because now it's sounding that there's two separate opinions. I mean, the statement that I read out earlier is what I assumed. That's why we're having this meeting, and also the response is that was the intent. Supervisor Crosby, was your intent to proceed with 100% hand count audit of all the races, of all the ballots on election day, and also of the early ballots?
My intention was to hand it off to the county recorder and county elections director, and that's what we did.
Okay, and then that. And
But,
so
but
that,
you didn't have the authority to hand it off to the county elections director.
My understanding is that the county recorder has volunteered to do so, and if he wants to correct me on that, he may do so.
so that's also confusing because it seemed like the county recorder was going to put together this hand count from the work session. The county recorder was the one implementing a plan or displaying a plan. According to the voted upon agenda item, the attached was the county recorder Stevens plan. So, and all together with all the comments was nothing will take place or displace anything that's happening on the normal elections tabulation process. What the election department does, this is in addition to, so that Recorder Stevens would be taking this process. That's seems like what the direction and comments were. So now I apologize, but I'm even.
Well, we will definitely allow Recorder Stevens to be in charge. That was what was stated in the thing. Recorder Stevens or other assigned election official. We would allow him to be in charge. The thing is, tomorrow we have a meeting and we would be discussing what this might look like and how it would be possible, if at all. It's hard for us to answer this right now without just saying, yes, we'll do it as best we can according to statute. We will conduct an expanded precinct hand count audit under the statute, according to the laws. She's saying that that's a possibility. She doesn't say don't do it. She says not do the full 100% everything. And I had already known, I think I probably spoke to 2 or 3 different reporters telling them that this is not going to be every single ballot measure on every single ballot because we can't. We had already found that. We found all these statutes. I found all these statutes on my own and then talked to different people about them, and we know they exist. We didn't ever intend to break the law. And that's what I said. I don't see how this is unlawful or illegal. And I just want to answer her. I know her. I sent her a nice letter saying thank you. I want to tell her we will do as big of an expanded precinct hand count as we can under the statute, as we're allowed. And if we start going astray, we'll apparently have to, next agenda item, ... Sorry about that. And I don't plan to go astray, though. By the way, that's not what I was saying. It would be nice to have advice from the secretary or whoever. I don't plan on going astray. So, oh no, now I'm the one doing all the talking. I can see Crosby, but he can't see me.
Limited information because this isn't something that others have done.
It's something that was done for a lot of years in this county. My mom said she had counted every single time she ever worked as a worker, And there were 3,500 people in Wilcox at the time when she was a worker. Now there's 32 something. We went down. But I feel like it's just easy. My mom said it was actually kind of fun, and it was just what they did every single time. I need you to know that. This is not, it's not for some personal thing. I want to just answer the Secretary of State, who has been my friend right across the hall from me in the legislature. And I just want to answer her and tell her we are going to do this lawfully. We intend to do this lawfully.
So I think Supervisor Judd, the question becomes, are you comfortable with Supervisor Crosby's letter? Do you want a line added to it, et cetera? I don't hear Supervisor.
Add a line. I like that he said, help us, reach out. We've got Recorder Stevens is the person we asked to run this. Reach out to him. This is a discussion you should have with him, because we've given him that authority. I like that, but I also would really like to say, if Supervisor Crosby could handle it, I'd like to say we intend to conduct, as you mentioned. We can leave out the 100% thing, because obviously it's not going to be if we do it with statute. Conduct as big of an expanded precinct hand count as we can. We want to do that. As far as it's within the statute. I never intended to go outside the statute.
Madam Judge's points are well taken.
So would one of you state exactly, and for the record, what you want in the letter of response to the letter the Secretary of State sent us? So
yes, let me start with mine, and Peggy can add her sentence. Does that sound okay?
Okay.
Okay, to repeat. Dear Secretary Hobbs and Ms. Corrick, we know we have lots of work to do. If you care to assist, please contact County Recorder Stevens or Elections Director Mara. Best wishes in your future endeavors.
Can we add best wishes at the end after my statement?
That's fine.
Thank you. My statement is, we received your letter. Or no, we don't even need to say that. Obviously we did. The board wishes to follow all applicable requirements in statute and the EPM when conducting its expanded precinct hand count audit. That will mean that there will not be a full hand count of every item on every ballot. Is that okay, Crosby? Supervisor Crosby?
Yeah, that's fine.
Okay.
And actually, that is simply restating what the vote and agenda items were on the 24th. That's fine.
Yeah. And it is simply restating item number 2, adding that we do not intend to conduct the full hand count because it's not statutorily okay. So.
Have you been given enough direction
For this response? Yes.
I don't know that the agenda item said direction and action regarding a response. So do we need to have a separate motion that all that is stated in, or the collection of ideas that they put together? Is that enough, what you call direction?
I think that there should be clear on the record the direction of that there is going to be a written response. That's what it sounded like to me. And what the response is going to be, and who will be signing the response. It needs to be clear on the record.
The one thing that we haven't addressed is who would sign the letter. You know, the letter was addressed to the board. I don't feel left out of this, but I don't feel that I can offer anything that's constructive at this point, because I haven't felt it was necessary to do this, and I certainly haven't seen any details of how it could be done. So, who would you like to author or put down these words that you have suggested and sign?
I would be happy to sign, but I can't be there. Kid's sick again, and we have an appointment at 4, so I can't be there. I'm hoping that maybe we could use a stamp. Maybe that seems inappropriate in this case, but
She can electronically sign the letter.
oh, okay.
Does that work for you, Supervisor Crosby?
Yeah, I think I can come up with an electronic signature.
So we
So
both
I
can
think
sign
the
it.
Consensus is they both wish to sign, and that's fine with me. So, in order to bring this, full circle, we have the consensus of wording of what they wish to desire, which broken down means that they wish to have an extended hand count, but they promise that they'll follow all the laws. Is that a thumbnail sketch of what you have wanted, Supervisor Crosby, Supervisor Judd?
Yes.
Yes, and I would like to keep the language as closely to her suggestions as possible.
The one thing I'm in my mind I'm objecting to is the fact that you have leaned heavily on the recorder, and I don't have a problem with that. But you've also mentioned the elections, and we have an election coming up. We have only 3 people in that department. They are working, full time in order to provide us with a safe and secure election. And so, in your message to the Secretary of State, you mentioned the recorder and the elections director, and I'd like to have that withdrawn because I don't
No,
want-
no, no. It says or, not and.
So or should be okay.
I could comment further. I could comment further if you'd like.
I just don't want any pressure put on so that it would be chaotic in the elections department right now.
Okay, now you can, Mr. McIntyre's right here. What I understood from the meeting on the 24th is he was urging, happens to be item number 1. Somebody'd have to get into all those meeting minutes and sort it all out, what was said about what agenda item. But Mr. McIntyre said that basically Ms. Mara does not have to do what was directed, I believe, in number 1. So that means we got to figure it out. If you want to go back and see what he said about that, then you're welcome to do so. But nonetheless, it says county recorder or elections director. That was number 2. It's been passed off to either or. Okay. Now, if Mr. McIntyre is going to direct her not to participate in number 2, then that's between him and Ms. Mara. Now, I addressed this yesterday in a memo to Mr. Maddox, I believe, but it goes along with several other things that Ms. Judd said. We don't have all these pieces sorted out. So you can either make the response like we've talked about, or Katie Hobbs can wait.
I think we've decided that they will both sign the letter, and we have the wording that they have put forth, and I'm sure Tim can translate that for you. Yes. Okay. And we had a motion and a second on the floor about direction. I'm not sure how we vote on that at this point, but I guess we have a motion and a second, so there must be a vote. If you think that we have the direction that you wish, I can call for the vote to make sure that you're still both agreeable. And so
Can I
that's what I'll
amend?
do at
Can
this
I
point,
amend
unless
my
you want-
motion? Can I amend my motion? Just add a line to it. attorneys? Just a quick sentence
I think
added
you
to the
need
motion.
Be very clear, because the motion was to have direction and discussion
Oh,
about
okay.
the response. You've come to an understanding of what, or consensus of what it's going to be. I think right now you need to just direct the staff to do what it is you want them to do, without having
Okay.
to make another motion on it.
Okay, so what about the vote? So we're just voting to have the direction and
It's just
response.
that probably what you wanted is in the wording of what you're sending to the Secretary of State. So right now, I think we've come to a consensus of the direction and the action in the response. We've come to the conclusion of who's going to sign this directive, and I guess we all agree that that Tim will put the letter together. Is that correct? Any comments about that?
Can you do that?
So now we have its direction and action regarding a response to the Secretary of State letter dated October the 25th, 2022. So all those in favor say aye.
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 Chair votes aye, and we'll send it to the Secretary of State. Second one is there any need for the legal representation discussion?
Well, it's agendized, and I do believe there's very much a need.
Okay, so second item is direction and action regarding obtaining outside legal representation. And so I'm going to ask for a motion so that it can be discussed thoroughly.
Madam Chair, I move that we discuss direction and action regarding obtaining outside legal representation.
I'll second it.
Okay, so we have a motion and a second, and now I'm going to turn that over to either Mr. Kowalczyk or the county attorney.
I would have the county attorney, Brett McIntyre, proceed first.
Thank you. So members of the board, situations like this do not arise regularly, thankfully. This county, the last time I can recall, was either 2012 or 2014. And so given the advice that I have given the board and given my position as to the legalities of the issues here, I think it's very appropriate that ethically, first of all, in the event that the board should incur litigation over this, you will need an attorney or attorneys in that to respond to that litigation. And second, in light of the discussion about how the hand count will be conducted, and especially going to make every effort to comply with the law for hand counts, those kind of things. If issues arise during that process, I think there would be a conflict in my office attempting to represent or respond for the board as to those issues. So what I would suggest is that this is one of those situations wherein the board is entitled to select counsel. We have reached out to a neighboring county about some potential outside counsel, and what I think the board needs to do is approve someone to engage that outside legal representation, especially in election matters. They are because of their nature, they're scheduled on a very fast track basis, and so I believe the board needs counsel for issues related to the hand count and item number 2 from Monday's agenda from here until that process is complete.
Well, I'm sure that the board members, all of us, were aware that we were going into these sessions with the idea that the board wanted to have a 100% hand count, and we're told that that was illegal and still moved forward. So that means that you probably have thought as board members, who would I get to represent me? And I think now would be the time for you to say who were you thinking was going to represent you if the county attorney who normally represents the board is not going to be able to do that.
I have two statements from my attorney, which I would like to read for the record. Number one, sent today, Katie should consult her own elections manual. And number two, from October 25th, last time Katie was in court, the taxpayers of this state got hit with a $2.75 million federal jury verdict thanks to her racial and sexual discrimination. If she sues, we will vigorously defend ourselves from this desperate publicity stunt by a proven loser in court. That's by Timothy Lasota, Esquire, dated 25th.
Is that going to be your choice of someone to hire?
Well, it might be and it might not be.
Because we're responsible for paying for our own attorney, I have a different kind of statement. I have not yet sought legal advice, but I have a few on a list that I could call, and I don't know that it is important to disclose who our attorney will be at this time. It's on me. I can't.
I want to clarify something. The thing that I'm talking about primarily is an attorney that represents the board as an entity. That'll be that will be the one that the county is then relying on for these issues.
I can find someone.
In the event that there are personal claims against individual supervisors, then yes, that would be separately. You as individual supervisors would seek your own counsel. I do need to note that Mr. Lasota is actively involved in litigation against the county, and it would certainly be a conflict of interest for him to represent the board as an entity. I'd have to leave the legal question to another day as to whether he could represent, for example, Supervisor Crosby as an individual. But the action the board needs to take today is to authorize someone, and typically in these situations it is the county administrator, to essentially, once council has been selected, then to sign the fee agreement, etc., for the board's lawyer, not for an individual board member's lawyer, but for the board's attorney.
Would you mind if I found if I made suggestions for who that is, but I can't do it right now? Maybe not for who we would choose, but so we had options and possibly even attorneys that would not cost the county a lot of money or would be funded by another source.
I don't plan on incurring any costs because we're going to win.
Okay, but nonetheless, there are costs associated with retaining a lawyer, always. Someone has to essentially authorize that to proceed and authorize whoever it may be, to engage in that fee agreement. Now, it's often the chair of the board or the county administrator.
Mr. McIntyre, I appreciate your concern very much. I'm not going to give anybody the opportunity to make political hay that I am incurring costs to the county.
Right. And I do, my contacts are either have funding or can do pro bono work. So I'm going to need to think. Can we table this item so I can think for a day? We are going to have a meeting tomorrow. Maybe we could add this on or on Friday sometime, do another meeting. I can't. I need to come up with some names.
So the board can always make a motion to table. However, tomorrow is a work session. It's not a voting, it's sort of informational. So we couldn't add this on to the agenda item.
Okay.
The only, if I may, please correct me if I'm wrong, if there is a motion to table and a second, and this moves on to let's say, a regular board meeting. In between then and now, if any kind of legal action is taken, we would have to have another emergency meeting to then find counsel and hire counsel and agree to whatever agreements are at that point in time. This is anticipation of any possible action, but that's why I just want to clarify. So there's a possibility of motion to table in second if there's no decision done today.
I think we never want to be without legal representation. And if the county attorney has excused themselves from this process for whatever reason, then we need to make sure that we're covered so that we have someone that can give us advice. So would you suggest that we authorize either the county attorney or the county administrator to secure legal representation for the board in the interim? Can we just authorize that, or do we need to have a specific name?
Well, I think the issue becomes, and just to clarify, as to for whatever reason, ethically, it is my duty to you as a client, in light of the advice that I rendered, to ensure that you have counsel, given that our office cannot ethically proceed as your counsel as to this issue. And so,
because we didn't listen to them in the first place.
What I suggest, and the only issue that would arise is if there is a dispute amongst supervisors of which lawyer it should be, as it were. What I would suggest is that the board take action to authorize county administrator or the chair to retain outside counsel for the purposes of any litigation as to action item number 2 from Monday's meeting, or any need for discussions or immediate responses, etc., legal inquiries regarding the county's execution of action item number 2. If Supervisor Judd is going to obtain some names and Supervisor Crosby may or may not have names, then I think it is sufficient to give someone the authority to engage on behalf of the county and outside legal representation. And our office, again, we did reach out. We do have 2 suggested names that are used as outside counsel by another county, specifically regarding election issues.
Well, you mentioned the chair. I really have no knowledge of the legal community, and so I would ask you not to put me in that position, because it would be like me trying to choose from something and I have no knowledge. So I would ask, since we've said direction and action regarding obtaining outside legal representation, that we vote to do that and authorize the county administrator to spend whatever funds are necessary in order to secure outside legal representation. Would that satisfy the group?
I'm not interested in that.
Okay. Thank you, Marissa. Do it. Bye-bye. Okay, so I believe, I mean, I can't tell you for sure, but I believe I can get a couple of people at least to choose from to work pro bono for us. And I just made a quick phone call to check, so that might have been illegal, but I did it. It's not an executive session, so it's okay. I just wanted to do
Attorney-client
it.
privilege.
There we go. But I did. I made a phone call quick, and I think I might be able to have some people. So can we have enough time to do that?
We can table it, or we could just reject the issue till a further date.
Well, if it were just you 2 being hung out to dry, I guess I could let you do that. But, I'm part of the board also.
Well,
I
I understood that you didn't want to sign the letter. Madam Chair, you didn't want to sign the letter that Madam Judd and I
We voted
contemplated.
yes. Okay. I would like very much to have a chance to present some possibilities, but I don't have them right now. And I don't know they would be bad counsel. I don't know why they would be bad. So, but then I would let you guys decide. I just I don't feel comfortable incurring costs. There's just too much going on right now. I don't want to incur costs to the
I don't want to
taxpayer.
incur any costs, but you want to do a hand count that you think that's going to cost nothing?
Madam Chair, if you feel like you need legal representation and, you're and you didn't want to sign the letter, I don't know what to tell you, okay? I think we're going to win. And this is the direction we're going. If you don't want to be part of it, I recognize that you're not a part of it. And there's been many, many times that I have been outvoted, as you're well aware, and I still have to accept the direction of the board in most cases. That's the way it goes. Where, basically you haven't done that. So I don't know what to tell you. I don't know how things work all the time. We do continue to be individuals, even though together we're a board and so on.
So I just want to point out that the board, much like a corporation, cannot represent itself in a legal action. So as an example, given that this is an expedited election matter, if someone were to file suit tomorrow morning, and then there would most likely be a hearing set early next week on an expedited basis, at which the board needs a legal representative, because none of you individually can come in and say you are defending the board because you're not lawyers. Those are the rules for the court process. They're not rules that I create. It's just the law. And so I think the objection is to the language used by Chairman English of expend whatever funds necessary. And I understand that objection. It is possible that there are lawyers who are willing to serve pro bono, and that Ms. Judd may be able to provide those names, things like that, or maybe that someone would contact Mr. Crosby or Madam English. So perhaps that's a suggestion that the direction you provide to the county administrator is that you do in fact authorize him to obtain outside legal representation at as little or no cost as possible to the county. Because again, every attorney that I've ever worked with requires a retainer. And so I can't see how the board obtains legal representation absent it being a pro bono lawyer without paying a retainer and signing a fee agreement.
Okay.
Can I also offer a suggestion? There is going to be a special meeting November 1st. If there's a motion to table this to November 1st, and then with the understanding that at that time names will be provided so that we can proceed. Now there might be an emergency meeting need to happen prior to that, but that's the next
It's not
schedule.
now that we'll need to do that
Right.
on November 1st.
So I understand there's a lot of confusion going on and discussion. But
Right.
If we can move to, if that's the direction is to move to table it to November 1st, we can add it on to that meeting. And also at that time, if either of the supervisors want to provide suggestions and direction at that time, then we can proceed.
Okay. And
Is
then
that fair?
something that I think I'd like to see is this, the documentation, maybe in statute or otherwise in the county, that tells us how to proceed in this situation. I know it doesn't happen very often. It's been since 2012, but certainly there's some sort of case document or something. That would be really helpful.
I think anytime the county attorney recuses themselves, we have to have representation, so.
Okay, but it must be written somewhere. That would be good to have for when I'm searching. Because maybe they can't come from just some random firm somewhere. They want it, I think it might be important if we have that in writing, some sort of documentation in a bylaw type situation.
There isn't any specific guidance that's provided
Okay,
by
okay.
these laws or by statute.
That's gonna help probably in my search. Okay, thank you.
All right, now remember, if you want to table this at time certain, if you want to table it today, then it's got to be noted
To November
when.
1st,
And November
suggested.
1st is the next time that we know that we have a scheduled board meeting.
Okay. Madam Chair, I would like to make a motion to table this item till November 1st with our regular scheduled board meeting,
Second.
10 a.m.
Is there a second?
November 1st at 10 a.m.
Second.
She said,
We have a motion and a second to,
excuse me, Madam Chair, I just want to clear up the motion, because I believe the November 1st meeting is a special.
It's a special meeting.
And she said it was regular meeting. So the motion should be to table this item until November 1st at the special meeting at 10 a.m.
Okay.
The clarification, Peggy, is that the title of the meeting, it's not a regular meeting, it's a special meeting.
Oh, Madam Chair, so I'm going to amend my motion.
Please.
Madam Chair, is that okay? Do we need a vote before I amend?
I think there was a second.
He did second it. So let's, would you like to remove your second so that she can amend her motion?
I remove my second.
Thank you.
Okay,
All right,
here's
go
the new motion. Madam Chair, I move that we table this item until our next scheduled meeting, which is a special meeting on November 1st at 10 a.m.
Second.
Okay, I have a motion and a second. All those in favor say aye.
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 Chair votes aye, and it is so ordered. The next regularly scheduled meeting we have is on Thursday, October the 27th at 1 o'clock at the Board of Supervisors Executive Conference Room for a work session. So not a meeting scheduled, but a work session. That being said, meeting adjourned.